I got into the decision a little bit on my Wednesday stream, but I hadn't yet read it in full, so I want to come back to it. General summary is parents of supposed transgender kids and a doctor challenged Tennessee's 2023 ban on transgender hormones, puberty blockers, and surgeries for minors, on the basis that the law is somehow unconstitutional. The Supreme Court released the decision on Wednesday saying no, Tennessee's law and therefore similar laws now enacted in about half of states are fine. There is no constitutional prohibition against them. And of course, the idea that there is some kind of constitutional right to physically meddle with your kid's gender was always ridiculous. Whatever opinion you may have on policy, removing that policy decision from the people in their states was never the intent of the constitutional framing or the 14th Amendment after the Civil War. But I want to understand the argument nonetheless, because this move was a major gamble for the transgender activists. With these new laws coming into effect, they had two options. One, just take the losses in the states enacting these bans and try to change those laws over time, or two, try to make a federal constitutional case of it, which is the route that they took, but that route carries major risk, because this is a Supreme Court that is not inclined to seize control of this issue away from the states. So if you fail, you're actually in worse position because the state laws that you don't like still stand, and now there's Supreme Court precedent affirming who holds rightful political power on this issue, and it's not you. And actually, the risk is even bigger than that, because at least in part, this decision doesn't just uphold the state's rights to restrict gender transition practices for minors. In its concurring opinions, this decision says that transgenderism isn't even a constitutional basis for discrimination claims at all, like race and sex are. In other words, the activists didn't just risk losing this particular battle in Tennessee. They risked damaging all their legal fights nationally in the future, and now they have. In choosing the wrong battle, they may have lost the war. In picking the fight, the transgender activists had to pick their legal path, and they plausibly had to under the 14th Amendment. I say plausible to mean loosely connected to precedent, not to imply that they make any sense. They could have gone the substantive due process route, the famed Roe v. Wade theory that the Due Process Clause protects certain unarticulated rights like abortions or birth control, or theoretically, in this case, pumping your kid with drugs to try to make him a her. But the problem is, at least with abortion, this court has been very substantive due process skeptical. They didn't undo the entire doctrine when they undid Roe, but the prospect that this court was ever going to say, yeah, those Reconstruction Amendment guys, when they were writing about freed slaves, clearly they meant that no state can ever restrict your cherished right to try to change your kid's sex with permanent physical alterations. That was never going to happen. So the activists had to take a different legal path. They said that this law violates the 14th Amendment's Equal Protection Clause. Likewise, that language was written and ratified after the Civil War to prohibit the enactment or enforcement of laws that treat people differently on the basis of race. And since sex involves many of the same characteristics as race, it's unchangeable, or at least it used to be. It has historically been the subject of many legal distinctions, some would say discrimination. And so the court has interpreted the Equal Protection Clause to include protections for sex that are lower than those for race against discriminatory laws. So the activists here tried to force their cause into this framework, saying that banning sex change procedures for minors is sex-based discrimination without sufficient reason, and or that transgenderism itself is a protected class or a suspect class under the Equal Protection Clause, like race and sex are. So transgenderism itself should enjoy heightened constitutional protection against discriminatory laws. And the legal analysis of those claims for the sane, honest, or even remotely constitutionally connected is very simple. No.
It's still a no. It will be a no. It is a no. No.
Chief Justice John Roberts wrote for the 6-3 majority, no, this is not sex-based discrimination. The relevant distinctions in the law are two: age, as in adults can do this activity, but not minors, and medical condition or medical use of the substance. Hormones or puberty blockers may be legally prescribed for some purposes, but not for the purpose of changing one's gender. You can't do it to little boys, And you can't do it to little girls either. So there is no sex distinction in the law. And as far as their claim that transgenderism itself should be a protected class, or a suspect class, as it's called in the equal protection legal doctrine, no again. Roberts writes, the court has never said that. Regardless, this law doesn't make distinctions on transgender identity anyhow. It doesn't matter what gender you identify as. You can't do this to kids of any gender, according to the law. So Roberts walks right up to that line. Hey, do you guys really want me to say that you're not a constitutionally protected class? Because I might. But Roberts writes, saying that actually isn't necessary to resolve this case since the discrimination isn't even present anyhow. So I won't cut you completely off like some of your preferred pediatrics practices. Roberts leaves that question, is transgenderism a protected class under the Equal Protection Clause, to live for another day, technically. But for the rest of the majority, it is clear that premise has no chance at survival. The rest of the justices line up in sequence to write separately just to say, hey, don't even try that theory, because it's total crap. Thomas writes that earlier cases have tried to claim that sexual orientation is a protected class under the Equal Protection Clause, but that's never happened. So clearly transgenderism is not an Equal Protection Clause protected class either. Barrett writes separately to say the same. Transgenderism is not a constitutionally protected class because per precedent, those classes have three characteristics. The group is defined by an immutable trait. The group has historically faced legal discrimination. And the group is a minority that is relatively politically powerless. And that test is strict, so much so that no groups beyond race and sex have ever qualified. And transgenderism clearly does not fit the requirements. First, it is not immutable. It's defined by mutability, actually. The fact that you can supposedly change your gender on a whim or even go back. See the detransitioners. Second, if transgenderism exists on a spectrum, it's not necessarily a category of A or B. It is not discrete. It's just an undefined blob. And third, as far as a history of legal discrimination, what is it for transgenderism? Race had slavery and a lack of full citizenship. Sex had voting restrictions and the suffrage fight. What is the history of legal discrimination against transgenderism? There isn't one. Mostly because the concept itself is ahistorical. It's a figment of the last few decades. It was invented, not naturally occurring. Alito tags in next just to go even harder. Hey, just so you guys know, I would have said, yes, this law does discriminate against transgenderism, and yes, that is constitutionally okay. If the Equal Protection Clause doesn't invalidate distinctions made on age or disability or poverty, if those things aren't suspect classes, then neither is transgenderism. So yes, write all the laws you want making distinctions about transgenderism. Those are constitutionally fine. And Alito is right, but you can tell he doesn't want even a breath of life in these arguments remaining. He gave him the full Krusty Burger treatment.
Why, you little... I got you! Go!
Oh, it's all just an act.
Stop! Stop! He's already dead.
No!
After such a thorough metaphorical beating, all the transgender activists have left for comfort are Sotomayor tears. Quite literally. Sonia Sotomayor writes the dissenting opinion, with Kagan and Brown-Jackson signing on, saying she does so, quote, in sadness, which is a very telling statement. So what? If John Roberts wrote the majority opinion with glee, does that make it better or worse? Does that make it correct or incorrect? What if John Roberts was even more sad than Sonia Sotomayor for all the kids already abused before this law was passed? Does that make him right? And the truth is, these opinions are supposed to be written with neither. They're supposed to be written with apathy or indifference, actually. Personal preferences are not to be influential. Only the application of the law is. If you want certain policy outcomes, you're in the wrong branch. Go over to the legislature. Well, sure, but then Sonia and company would have to work with hundreds of other lawmakers, and that's a difficult and inefficient process. Wouldn't it be so much easier and better if she could just craft the policy herself? You can see the recipe in the attempt to do that throughout this opinion. Oh, well, first consider just how important this issue is, Sotomayor writes. It is literally life and death. Indeed, the more transgenderism spreads, the more corresponding death there is. That's true, but for reasons different from what Sonia thinks. Regardless, from a legal and constitutional perspective, again, so what? Murder is the ultimate life and death criminal matter, and it's still under state police powers and jurisdiction. Very, very important doesn't mean reserved for the federal courts to decide. It means the opposite, actually. The closer to the people, the better. Because the more the issue matters, the more accountability matters. Okay, fine. If saying it's very, very important doesn't work, well, then let's try shoving this one into some existing doctrine to try to justify the Supreme Court's and therefore Sonia Sotomayor's personal control. Sex is a protected class, requiring higher scrutiny for laws that make distinctions on it. So this law is clearly sex discrimination. Because a girl who doesn't want facial hair can have a testosterone suppressant, but a boy who doesn't want facial hair can't. No, either can have it for a medical purpose other than trying to change gender. Neither can have it for the supposed medical purpose of trying to change gender. That is equal application. Medical use is the distinction, not sex. No boys or girls can be given physical alterations to try to change gender. Okay, fine, Sonia says. Well, then this is transgender discrimination, which can't stand constitutionally because in a 2020 decision, this court said that transgenderism is protected the same as sex under the Civil Rights Act. And that's true, they did say that, though I think wrongly, but even if you think that decision is correct, it's an analysis of a different law. The Civil Rights Act is not the Equal Protection Clause. That decision dealt with valid and invalid reasons for firing someone existing in federal statute. And this decision deals with the validity of the law itself if it makes distinctions on certain classifications. And to say that transgenderism is a suspect or protected class, you would have to undo the precedent that Barrett discussed on what that term means, that the group has an immutable trait, and it's a minority that's been subjected to a history of legal discrimination. Transgenderism is none of those. If you care about precedent, as Sotomayor claims to, you can't just force something from one context into another. You'd be loosening the standard of what a protected class is to the point that it's meaningless. A person can change gender at will, therefore a person can enter or leave a protected class at will, which is, of course, the point. It's not a mistake or a flaw. If we can invent protected classes at will, well then any legal distinctions made about them will be subject to heightened scrutiny in judicial review, as in Sonia's personal approval or not. And that is her argument. This is discrimination against a protected class. Therefore, the courts must evaluate it with heightened scrutiny, meaning examination of whether the law actually serves its stated purpose or not. And this doesn't, because it's contrary to expert consensus on the settled science of how awesome and beneficial changing children's genders is. In other words, assigning protected class status is a very useful way to remove political power from those pesky backward bumpkin people and give it to sophisticated judges and their expert best friends. But who is really the sovereign in this country, or at least who is supposed to be? Does the Declaration of Independence say that government rightly exists at the consent of the experts? Does the Constitution's preamble say we the people or they the experts? Thomas's concurring opinion explains the matter clearly. Quote, "The views of self-proclaimed experts do not shed light on the meaning of the Constitution." This language quoted from the Dobbs decision overturning Roe v. Wade. Thus, whether major medical organizations cited by Sotomayor agree with the result of Tennessee's democratic process or not is irrelevant. It is still their right to make that decision. And any holding otherwise would mean that the people hold political power only until someone more important disagrees, or until someone more important decides that issue is so important that the people can't be trusted to make decisions about it. This thinking from the same people otherwise heard lecturing you about the importance, indeed sanctity of, respecting the will of the people, always, no matter what that will is. If democracy really is your highest political value, well then, the conclusion to John Roberts' majority opinion should satisfy you. not just satisfy you, actually. It should turn your sad Sonia Sotomayor frown upside down, because this is deference to democracy. Writes Roberts, this case carries with it the weight of fierce scientific and policy debates about the safety, efficacy, and propriety of medical treatments in an evolving field. The voices in these debates raise sincere concerns. The implications for all are profound. The Equal Protection Clause does not resolve these disagreements, nor does it afford us license to decide them as we see best. Our role is not to judge the wisdom, fairness, or logic of the law before us, but only to ensure that it does not violate the equal protection guarantee of the 14th Amendment. Having concluded that it does not, we leave questions regarding its policy to the people, their elected representatives, and the democratic process. If that deference to the people to make their own rules in their own states brings you sadness, well, that's fine, though legally irrelevant, but you can't claim democracy as your highest value. Things that make you personally happy are. And if your political philosophy is just stuff I like should be the law of the land, no matter what other people think or what moral truths may be sacrificed in that effort, well, you actually have quite a lot in common with the tyrants you might otherwise be warning or taking over the country. I'm sad, so I should be the boss. That is the philosophy of a tyrant, just a much more pathetic variant. It's the same centralized control, but at least a strong man actually earns it through, well, strength. People listen to him because he can beat your ass, not because he can't stop crying. If we're going to do tyranny, can we at least get some respectable ones? Make tyrants tough again. Even the British crown had regal elegance and the greatest military the world had ever seen. Since all of this is supposedly a debate about the intent of the constitutional framers and the 14th Amendment authors, if only they could inform us now. If only we could ask them, hey, was the Constitution's intent to empower this lady to require that trying to turn little boys into little girls be legally protected across the entire country? If they even understood the premise of the question, it might be absurd enough to get the Georges back together, as in Washington and the King. Sure, they had their differences, but compared to Sonia and company, how different were they really? Constitutional republic, monarchy, whatever keeps that lady out of power will probably work just fine. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X, that is at ML Christiansen. You're always welcome to coming out and chatting my live streams as live on Wednesday and Sunday nights. Looking forward to it. Come on. Hey, if you made it all the way to the end of the video, that means you probably found some value in the video. If you found some value in the video, please consider supporting my material. You can do that one time or recurring for as little as $1 a month. It not only helps me sustain, but it helps me pay the people who make my videos possible. Linked in the description for you, mattchristiansenmedia.com/support. Thanks for listening.